Hello and welcome to part 4 of this Field Seymour Parks webinar. This follows on directly from parts 1 to 3, and in part 4 I'm going to be looking at complications that can arise when you're dismissing somebody for long-term sickness absence. I'll be running through some common challenges that my clients have experienced dealing with these sorts of scenarios, and finally there'll be a bit of a recap, a summary of the content that I've gone through in the previous parts of this webinar. So, complicating factors, a couple of slides on this, and this is in the context of dismissing somebody due to long-term sickness absence. And the first one I wanted to talk about is permanent health insurance. Now, as you may be familiar, permanent health insurance will generally provide an employee with some form of benefit, and it's normally a percentage of their salary if they're unable to perform their duties due to ill health, and quite often you'll find that PHI cover kicks in once an employer's own company sick pay provision has been exhausted. It's important with the PHI cover that you check the rules of the particular scheme, if this is something you have in place as an employer, because often the definition of when somebody qualifies as incapacitated for the purposes of PHI eligibility, often the case that that's quite narrowly drafted, and you'll need to review the scheme rules to ascertain whether or not your employee on long-term sick leave would or wouldn't benefit from PHI cover. If you're satisfied that they would benefit from PHI cover, then you'll generally find that these PHI policies will require somebody to remain an employee of the company in order for them to be eligible to receive benefits. And there's a case on PHI cover, which is I've mentioned on the slides, so Aspden and Webb's Poultry, and that case is authority for the point that you can have, if you have rather an express term in the contract saying that you're entitled to dismiss somebody regardless of whether or not they're in receipt of these sorts of benefits, that will actually be overridden by an implied term that you as an employer will not terminate the contract of employment while an employee is in receipt of PHI benefits. So this won't apply to all employers. Many employers won't have PHI cover in place. But if you do have PHI cover, then it's certainly something I would recommend that you take advice on in advance of confirming any dismissal, because it could land you in some hot water. The second complicating factor I wanted to address is this concept of a contractual right to dismiss if an employee is unable to perform their duties for a certain period. And quite often you'll have a clause in a contract which says if an employee is unable to perform their duties for X weeks in a 12-month period, so it might be 26 weeks, be quite a common figure, then we are entitled to dismiss without providing further notice. So quite a common clause, and it's in the contract to avoid a breach of contract claim for the employer dismissing the employee without providing further notice in this sort of scenario. That can be useful where you've got an individual who's been off for a long time, but they also have a very lengthy notice period, and you want to avoid having to provide that period of notice. However, it really does need to be exercised with a bit of care, because what it doesn't do is just give you carte blanche to dismiss somebody with no risk of tribunal claims. You are still going to have to follow a fair process. So, and this is all the points I've covered in the previous parts of this webinar. So investigation, medical evidence, consultation, invitation to a formal capability meeting leading to dismissal, all of that, you're still going to need to cover it off, because the clause in the contract that you may have doesn't defeat or prevent the employee from bringing a claim of unfair dismissal, or if they're disabled, a claim for disability discrimination or failure to make reasonable adjustments. So I think perhaps for some employers there's a tendency to look at that clause in the contract and see it as a bit of a get out of jail free to sort of dismiss with no consequences. Unfortunately, that's not the case. It's just designed to avoid that breach of contract claim, but if you rely on that without doing any other investigation and following a fair process, then you are likely to face claims in the tribunal for unfair dismissal and disability discrimination. The next slide on this deals with quite a technical legal point surrounding notice pay, and if you're particularly struggling to get to sleep at night, you can go and visit sections 86 to 91 of the Employment Rights Act 96 and read it for yourself. But since you probably don't want to do that, I will try and summarise what that says for you here. So essentially, where you have an employee who is unable to work due to illness or injury during their notice period, and the contractual notice that they're entitled to receive from their employer is less than 1 week more than the statutory minimum notice that they're entitled to receive, then that employee must receive full pay for the statutory notice element of their notice period, even if they've exhausted their entitlement to company sick pay and statutory sick pay. So by way of example, if you have an employee who has 4 years service and a contractual notice of 1 month, so the employer has to give 1 month's notice to terminate that individual's employment, the contractual notice of 1 month is actually less than a week more than the statutory minimum notice that that employee is entitled to receive, because an individual with 4 years service, their statutory minimum notice will be 4 weeks. So as a result, you as an employer in that scenario would have to pay the employee at their full pay for the statutory minimum notice part of their contractual notice, which means for the 4 weeks, which is their statutory minimum notice, out of the 1 month contractual notice they're entitled to receive. This rule ultimately operates to give employees a bit of a windfall in some circumstances, really, just depending on whether or not the contractual notice they're entitled to receive is less or more than a week greater than the statutory minimum notice. So if you had somebody with 4 years service but they were entitled to receive, so if you had someone with 4 years service entitled to receive 3 months notice, for example, then this rule wouldn't apply, and if they'd exhausted their entitlement to company sick pay and SSP, then they would not be eligible for any further pay during their notice period. The rule also applies to scenarios where the employee is giving notice, but in that case the maximum that you would have to pay out as an employer is 1 week's pay, because the statutory minimum notice for employees is always 1 week regardless of length of service. Now, the way in which this rule operates could give you a bit of pause for thought, and you think, well, if I just make all of my notice periods a week greater than the statutory minimum notice, then can I circumvent this issue? And the answer is yes. Yeah, you would be able to defeat this outcome, but then you're giving all your employees an entitlement to a week's notice more than they would otherwise have received. And these sort of long-term sickness cases are quite rare, so do you really want to amend your standard notice clauses in your contract for all employees to cover off a situation that's only really likely to arise quite rarely? So there are ways around it, but whether or not it's really economical in the grand scheme of things is another question. If you are not serving somebody with notice, but paying them in lieu of their notice period, then I would recommend that the cautious approach here is to pay out based on what the employee would have received had they worked as normal during their notice period. There is an argument to say that if you have wording in the contract of employment which allows you to pay the employee in lieu of the pay they would have received had they remained employed during their notice period, then you could try and run an argument along the lines of, well, had you remained employed during the notice period, you wouldn't have been entitled to any money, and that would be the case if they'd exhausted their entitlement to company sick pay, to SSP, and the notice period due from the employer was more than a week greater than the statutory minimum notice. And you could try to rely on that interpretation of a clause in the contract to say, well, I'm going to make you a payment in lieu of notice, and the payment I'm going to make is nothing because you're not entitled to anything. That's not what, you wouldn't have earned anything anyway. However, that sort of argument is untested as far as I'm aware. You'd need some very tightly drafted wording in the contract, and I think it's probably a bit of a high-risk manoeuvre, frankly. So I mention it, if you'd like further advice on putting something like that into practice, then do feel free to contact me. But I think the standard approach is if you make your payments in lieu, you're going to need to make a payment in lieu of what that employee would ordinarily have received had they worked their notice as normal. So moving on then to some common challenges that clients have experienced in dealing with these long-term sickness absence scenarios. There are a few examples there on the slide. Obviously there are more challenges than just these four, but I've picked a few that come up quite a lot. So firstly, if you've got an employee who's refusing to attend medical examinations, what can you do about that? You need the medical evidence in order for you to fully understand the position. It's a bit difficult if they're being obstructive about it. The first point is I would check their contract of employment. A well-drafted contract will ordinarily include an obligation on the employee to attend an occupational health assessment which has been organised and paid for by the employer. So if an employee is initially being a bit reluctant, you can point them towards that clause in their contract, and ultimately you could treat it as a disciplinary matter, so a misconduct matter, if they're unwilling to attend a medical appointment. I would also recommend that any company sick pay provision is specifically linked to an employee's compliance with your sick leave procedures, and including this recommended obligation to attend a occupational health assessment, because then if the employee won't go along with trotting off to an occupational health advisor, you're in a strong position to withhold company sick pay, and I think in a lot of circumstances that's likely to encourage the response you want, which is that the employee agrees to go off and have an occupational health assessment. Ultimately, if you get to a bit of a stalemate on it, the employee's refusing to go off and have any sort of medical report prepared, then you may just be left in a situation where you have to take action based on the investigation that you've carried out to date and what limited medical evidence is at your disposal. The second common question, if you've got an employee who refuses to attend consultation meetings, so it's a similar point really, I would be accommodating at first, particularly if the reason that the employee is giving is that they're unable to attend for ill health reasons. Perhaps they've got a hospital appointment coming up or some other sort of serious form of treatment. Likewise, if the employee or their companion are unable to attend, then you are required as an employer to reschedule that meeting for another time within the next 5 working days. But ultimately, you can, if they are repeatedly refusing to attend these meetings, hold a meeting in their absence. But before doing so, I would always give them the opportunity to make written representations that you can take into account at any consultation meeting. So yeah, that's really the sort of last straw. I would try as much as possible to rearrange and reschedule meetings, because it's just going to make you look, it's going to reflect better on you as an employer ultimately if the process that you followed is challenged and you can show that you've been very flexible and accommodating and rearrange meetings on a number of occasions. The third point here, the employee says that they're fit to work, but you disagree. I think if the health position is unclear, then really the safest course of action is to suspend them on full pay while you obtain a GP or occupational health report. Otherwise, it's quite a high-risk strategy to keep somebody out of the workplace if you've got no real grounds for doing that. That can potentially lead to arguments about breach of the implied term of trust and confidence, possibly result in constructive dismissal claims. But it's obviously going to vary on a case-by-case basis. I think if you do have strong medical evidence that you can point to, so if you've got a GP or occupational health report which is quite firmly saying something that's at odds with what the employee is saying, and that report has been prepared quite recently, then you're on much firmer ground to prevent them from returning to the workplace and just continuing to manage their absence and pay them in accordance with your company sick pay provisions or as per their entitlements to SSP, statutory sick. The fourth bullet point on this list, recruitment during long-term sick leave. So clearly if you've got somebody out of the business, you're not fully staffed up. There's a bit of a vacancy there really, and you want to fill it. You need somebody in doing the work. My advice would always be to recruit on a temporary basis in the first instance, and avoid permanent recruitment if possible. If it's, you can demonstrate that it's very, very difficult to bring somebody in on a temporary basis, and that you really need to have somebody in permanently. There just isn't the pool of talent there to fill that vacancy on a temporary basis. Then there's more flexibility. But the issue that you have is that if the employee who's on sick leave then recovers and returns to work, you're then over-resourced, and it can be difficult to effect a fair dismissal of either the employee on long-term sick leave or the employee that you've brought in to cover them. You can run certain arguments, but it's just a situation that's best avoided if possible. So temporary recruitment to cover the lack of resources is preferable. Okay, so that brings me to the end of the common challenges section, and I'll just finish up by running through a summary of all the different practical steps that I've covered during parts 1 to 4 of this webinar. So starting off with staying in touch, it's often overlooked, but very important to keep those lines of communication open right from the start and preserve that relationship with the employee who's off sick. Ensure the employee is aware of their reporting requirements in accordance with your sick leave policy. Make sure you've got copies of GP statements of fitness for work. Review your own company sick pay rules. Ensure you're familiar with illness-related benefits and keep the employee updated on their entitlements. Investigation is always going to be required in a long-term sickness absence scenario, and that's going to involve obtaining medical evidence from GP or occupational health, establishing, after review of that medical evidence, whether the employee might qualify as disabled under the Equality Act. If so, bearing in mind your duties to that disabled employee, avoiding discriminatory treatment, making any reasonable adjustments, and keeping a record of the decisions that you've reached in that respect. You'll need to consult with the employee, keeping a paper trail of the meetings that you've held, what's been discussed, in particular related to adjustments and any steps that have been proposed by either party or by a health professional related to the employee's return to work. And ultimately, you'll need to reach a decision on whether you can accommodate the employee's ongoing absence, or whether it's reached a stage where there's no foreseeable return to work and that the time has come to dismiss on ill health grounds. If so, it's always a situation that needs handling with care. It's important that a fair process is followed so as to minimise the risk of claims. One final point I would just encourage you to bear in mind is, what contingency plans do you have in place if a key member of staff is off sick? Sometimes you may have somebody who's involved on a critical project or is just a key person generally within your business, and not much thought has been given to how the business would cope if that person were to suddenly be unavailable due to ill health for an extended period of time. So just one final practical tip really is, do you have a bit of a plan in place should key people within your business no longer be available? So that's the end of this part 4 and the end of the webinar as well. I hope that you found it informative and helpful. If you've got any questions about the content that I've covered, please feel free to drop me a line. My contact details are up on the slide. And one final point, of course, everything I've covered here is general advice. If you've got a query on a specific scenario that you're dealing with, then do feel free to contact me or another member of the Field Seymour Parks employment team, and we'll be more than happy to help.